Hi everyone, I'm Anya from Anya Opperman Attorneys. We are a family law practice in the north of Johannesburg, and today I want to give you some more information about the terminology we use when we speak about children's matters. Now, this might sound like a very unimportant matter, maybe to members of the public and even to attorneys who practice in civil law or who do labor or criminal matters. But for us family law practitioners, it's really, really important that we use the correct language when we speak about children. And I just want to give you a little bit more information about why I say that. In days gone by, we used to always refer to custody of a child. One parent or both parents have joint or sole custody. And then if there's sole custody, the child would have a visitation with the other parent. The parent was awarded custody or awarded visitation. While there's nothing inherently wrong with that kind of thinking, the Children's Act actually has much better language that we use these days. This is Act 38 of 2005. So it's not even that new anymore, but surprisingly, the old language still slips through so many years later. And the reason for that is that as legal practitioners, we like to go and look at the way courts used to do things. We like to use old precedents because they've worked in the past. And that's why sometimes it's just a copy paste or somebody who doesn't quite understand that the different language is important. And those still slip through. The old terminology, you'll still find them sometimes in parenting plans. They might even slip through in a court order, hopefully not. The reason I feel so strongly about the wording that the Children's Act uses is that it just gives us a better background in terms of how we think around children. The Children's Act speaks about parental rights and responsibilities. Now, as a family law practitioner, I even like swapping those two around and referring to responsibilities and rights. It's just a little nudge to a parent to remind them that firstly, you do have responsibilities in terms of a child, and then you also have rights. You do have the right to have a relationship with that child. The child also has rights, and we've already spoken about the Constitution and the Children's Act, which dictates that the best interest of the child is the paramount principle in any disputes around a child. So it isn't predominantly about your rights, it's more about the child's rights, but that doesn't mean that your rights are unimportant. A child also has responsibilities for reasons that are understandable. Most children's matters really center around the rights of the child and not so much the responsibilities of the child. Now, when we look at parental responsibilities and rights, the Children's Act breaks it down and it speaks about care, contact, maintenance, and guardianship. Now, maintenance falls under care because it's the financial care, but it does warrant being mentioned by itself because it's a very specific way of caring for a child to pay for all of their expenses. The other aspects of care is more day-to-day care and to make sure that all of the child's needs are met. Let's just compare the word care to custody. A child is not an item that belongs to you. It's not something that you take good care of by putting it away in the cupboard and making sure that nobody steals it. We need to really look at the needs of the child, the emotional, scholastic, mental, medical, all of the needs that a person has, and make sure that the child's properly cared for. The child is in the care of a person, not in a person's custody, and the child then has primary residence either with the one parent or joint primary residence, which can mean 50-50. Which one of those is also a difficult question. The court will look at the child's age, stage of development, maturity. The child needs to have stability in both households, and the child needs to have the strongest possible bond with both parents. Obviously, we do have exceptions to that rule. It's very sad that sometimes a child needs to be protected against a harmful person, and then that might not be true, but generally speaking, if a parent is not problematic, we want them to have the maximum amount of time with each parent without compromising on the stability and the routine of the child. The other term that I've referred to is visitation. It's not problematic. We still use it. You can still have it in a parenting plan or in a court order. But contact just says, I'm not going there to visit. If you have primary residence with, let's say, mom, then you might be spending every second weekend and one weeknight with dad, but you're not going to visit there like you visit a grandparent or an aunt or an uncle or cousin's house or your friend. you're still living there, even though it's for a shorter period of time, and even though it's not your primary residence, it is still a residence. And for that reason, it's just much better to say that we are exercising contact with the child. It's the same thing, but it's a much better way of thinking of how we're going to take care of this child in two households, seeing as the family unit is no longer together. Now, there's a lot more information around parenting plans and co-parenting. Co-parenting can become extremely problematic because we know that we've got two different houses. They might have two separate sets of values. They might have two different ways of thinking around discipline and rules, what is acceptable and what is unacceptable, and those all need to be aligned to also give the child the stability they need between both households. I would love to give you some more information around all of that, so please like, follow, and subscribe.